Hello everyone, welcome to another video lecture. We're getting into our final unit this week, taking a look at this question about constitutional rights and the dispute between Waldron and Wallachau about them. So the dispute isn't really about whether or not we ought to have rights or whether or not certain rights are important, but rather it's really a question about whether or not the best way to have certain fundamental rights protected in a liberal democracy is by having them written down somewhere, some kind of constitution or constitutional document, which can then be used by the courts to review and potentially strike down pieces of legislation coming out of the legislative branch of a government, and whether or not it can tell the executive branch what it can and cannot do. So a way to put the issue is just this. Rights seem like good things to have. I like my rights, you like your rights, everybody likes to have certain rights. Now, should a liberal democracy, right, like Canada, the USA, or the UK, one that tries to strike some sort of balance between democratic majoritarian rule as well as individual rights and freedoms, that's really the liberal part of it, should a liberal democracy have a written constitution that contains the rights of its citizens or not? Right? And it might almost seem obvious that the answer would be yes. We're actually going to see today and on Wednesday when I post the second half of this lecture, Waldron's ultimately going to answer no. Why? At least a way of summing up the argument is because doing that is actually anti-democratic. Now that might sound weird. How can writing down people's rights be anti-democratic? Well, when I was talking about liberal democracy there just a second ago, I noted that there are two things. Democracy, sort of minimally, it's power of the people. It's demos and whatever that second Greek word is. I'm sort of drawing a blank for the moment. Democracy is just literally that power is arche. That's the second Greek word. Demos and arche turns into democracy, which just quite literally means the demos, the people, have the power, the arche. Now that suggests something like whatever the majority says goes. Of course, there's a question. What if the majority says, oh, let's, I don't know, kill the minority or treat them poorly, right, in some serious way? Well, the liberal part is precisely the part of having certain individual rights and freedoms. Now, Waldron, we're going to see, it's an interesting argument. You've got to follow some of the details to see how it works. Effectively, what he is saying is that having certain rights written down in this way is anti-democratic because it prevents the majority of the people or whatever decision-making procedure is in place within a democracy from actually determining what rights are and being able to revise those over time. Now, having a written document, some kind of constitutional document like this. So in Canada, there is a Bill of Rights from, I think it's 1960. Of course, the Canadian Charter of Rights and Freedoms, the first part of the Canadian Constitution, is the much more famous one, the one that really matters these days. In the United States, you have the Bill of Rights, really, the first set of amendments to the Constitution, which themselves are written right down. Now, the UK does have something called the Bill of Rights. It's from 1689 or something like that. And in some sense, it's part of the constitutional law of the United Kingdom. The interesting thing about law in the UK is that they don't have just a single constitution that's written down. So, in the United States, there's the Constitution, the American Constitution, right? It's this written document, and it's the focus of much scrutiny and much debate. In Canada, since 1982, we have a constitution. Well, there already was one sort of held over in Britain on our behalf, but eventually it was brought over, and then the Charter of Rights and Freedoms is part of that now. So we have this written document that lays out really all the fundamental workings of the government of Canada. Well, okay, not necessarily all the fundamental workings of the government, but really the fundamental framework within which legislation and democratic activity takes place. In some sense, the Constitution sets the rules within which the legislature and the executive within a country is allowed to act. So if a legislature tries to pass a piece of legislation which violates one or more parts of a constitution, what you have is something called judicial review. This is really the process by which members of the judiciary, so judges of some sort, have oversight of the other branches of government based on what's in the Constitution. Now, depending on the exact setup of the political system, this will be different. It might be a Supreme Court that does it. It might be a special constitutional court. So the exact procedure by which this is done varies, but the basic idea of judicial review is that judges have the power, when you have a written constitutional document that outlines rights, of being able to then look at other activities in the government, other judicial decisions, but really we're interested more here in acts of, say, the legislature, which in a democracy presumably are representing the interests of the majority of the citizens. Can judges then examine pieces of legislation passed by either directly by a majority of citizens or by the representatives of the majority of citizens? Can the judge review that and say, yeah, I know that's what the majority wants, and I know this is a democracy, but you're not allowed to have it because it violates one or more parts of the rights laid out in our constitutional document or set of documents. So Waldron is going to say no, because when I put it that way, all of a sudden, my saying that he argues allowing for judicial review is anti-democratic, that seems to make some sense, right? Because really what's going on, judges are striking down what should be laws produced by a majority of the people within a democracy. That sounds anti-democratic, particularly if the judges themselves aren't elected but are somehow appointed one way or another. We're going to see Waldron will answer, in fact, yes, we should have these rights written down in some sort of constitutional document. We should allow for the process of judicial review. We'll just see why next week. So we'll just set Waldron aside for now. We're going to see Waldron is going to disagree with Waldron and answer, well, actually, yeah, you should have this sort of thing happening, at least to some degree. Okay, so let's start taking a look at the reasons Waldron gives us for thinking that, in fact, writing down what rights people have in some sort of constitutional documents really not a very good idea. So for working through the Waldron piece, I've just tried to keep the headings the same as the section numbers. We're just going to work through it in order. So we'll just start with the introduction, and then we'll go along. We'll probably get to about section 6 or maybe 7 in this, this video lecture, and then we'll move on in the next one. So the basic situation that Waldron is considering this issue within is a debate that was going on in the late 1980s into the early 90s in the United Kingdom about adopting a written Bill of Rights, something like what the United States has, or say the Canada has in the Charter of Rights and Freedoms, that actually write down what sorts of fundamental rights all people have that really can't be overridden, or under what sorts of circumstances they can be overridden. So, you know, allowing people, say, to freely gather in public places, right, to gather as they see fit. Sounds like a great right to have. Of course, if you have something come along like, well, I don't know, a novel virus that has a pretty serious threat to public health and safety, should Parliament or whatever the sovereign body of, you know, whatever the legislature is within the democracy, should it have the power of actually saying, well, I know you normally have a right to public assembly, but maybe not for now because of overriding concerns. Or say a war happens or something, right? Or if you think back to, say, 9/11, which I know for some of you it might be an event that happened so early in your life, you haven't known a world before that. But after 9/11 occurred, there's this big move in the United States and other countries as well to introduce anti-terror legislation, which in some sense posed a threat to individual rights, because now it was allowing for things like wiretapping and surveillance on people who hadn't actually committed a crime, and it was trying to loosen certain restrictions on under what conditions people could be detained, held, investigated, and so on. So the UK, right, in the 80s, 90s, was thinking about adopting a written constitutional document like this, actually laying out what the rights of people are, because there just isn't something like that right now in the United Kingdom. That's not to say people don't have rights, But the rights they have are largely a result of the very long legal history in the United Kingdom and the sorts of precedents that have been set there, right? So, in fact, Waldron even talks about this, that our old friend Dworkin was involved in this debate, at least to some extent. And Dworkin advocated that, in fact, the United Kingdom should adopt some sort of written constitutional, Bill of Rights or something like that. Maybe it could have a different name, Charter of Rights and Freedoms, or whatever it might be. Dworkin argued that the United Kingdom should do this. Why? Precisely to encourage legal thinking in terms of rights and principles, his own favorite approach to how we ought to approach matters of law, issues of justice and fairness, rather than thinking in terms of precedent. So on 264, Waldron is talking about Dworkin's view here, and the way Waldron talks about the way Dworkin talks about it. In Dworkin's view, too much legal thinking in the United Kingdom that was really focused on just tracing lines of precedent about what sorts of decisions have already been made and how does that constrain future decisions. So you can actually determine what sorts of rights people have by taking a look through the legal history and seeing what the precedent-setting decisions are. Now, that introduces a kind of conservatism and a kind of conformity, and just in terms of legal thinking, winds up really narrowing the scope within which jurists, lawyers, judges, and so on, are actually thinking, because now they're no longer thinking in terms of, right, if we think back to Dworkin, what are the best sorts of principles that explain all the decisions that have already been made, wherever our explanation of what those principles are gets underdetermined, there are multiple competing principles that could adequately explain the sorts of decisions that we see having been actually made. Which principles are really the best ones? Which ones lead to a best society, the most just or fair society we might be able to have? And having arguments in those sort of big terms. Having the system like the UK does, in Dworkin's view, really sort of narrows the scope of juridical thinking just to this question of, well, what sorts of decisions were already made? So what are the limits, right? Really looking for the limits rather than saying, okay, what are the limits and why are those the limits? And are they really the best limits around? How can we reinterpret these things in the best way possible? Now, as we mentioned when we were looking at Dworkin, Dworkin's view itself lends to a certain kind of conservatism, but not necessarily. It also opens the door in some sense for reform and evolution or progress within the legal system. Now, in the introduction, Waldron, after he sort of briefly articulates what the situation is and that Dworkin was involved, he outlines his 4 argumentative approaches. Now, I'm not going to take the time to actually talk through that. He outlines them very straightforward manner. There's 4 different paragraphs, and he sort of goes, okay, so first, second, third, fourth. So we'll just jump right into it. But that's page 264, 265, where he gives this outline. It's a very nice little outline. It's a good synopsis of the piece. So if you're finding yourself getting lost in the details because the piece is fairly long, this is a good place to go back and to just find a very short, basically 1-page summary of the overall outlines of what Waldron's trying to do here. Okay, so let's move into section 2, just take a look at right-based theories. And like I said, we're just going to work through section by section, trying to take a look at what's going on, highlighting at least the main points. So as usual, there's going to be some details we're just going to have to skirt over, but they're there on the final exam. I am going to ask you to write an essay question of some sort on the debate between Waldron and Dworkin. So reading through is certainly advisable, and there might be places where you find some details you think are very pertinent that maybe I've just sort of skimmed over, and that's quite fine. Okay, so right-based theories, this first section, really the first thing Waldron is trying to do. As he puts it, my first aim is to show that there's no necessary inference from the premises of a right-based moral theory to the desirability of constitutional rights as a particular political arrangement. Okay, well, what does this mean? Well, really what we see here is this tension or connection we've been wondering about throughout the course between morality and law. So as you can see here, Waldron, is really talking about the connection between moral theory, if we have a right-based moral theory that says, okay, people have rights to X, Y, and Z, does that automatically mean that people should have X, Y, and Z as constitutional rights? Right? So somebody in our moral theory, we think, gets certain sorts of rights. Does that mean they should be given those rights on a constitutional level, in something like a written Bill of Rights or Charter of Rights and Freedoms that enshrines those rights right there in the basis of the legal system? Waldron's going to argue no, right? In fact, there isn't a necessary inference from a moral theory that says so-and-so has a right to X to the desirability of a constitution putting right in that constitution that everybody has a right to X. So he does this, and we've seen this before. We were talking about Hart and talking about Dworkin. The difference between a foundational and a coherence model of law. So on a foundational level, and it need not just be law, it could be anything, it could be epistemological theory, right? How our beliefs justify each other. It can be a moral theory, legal theory, really any sort of theory. If assuming it has multiple parts to it, how do those parts fit together? Well, one view is just purely intuitionistic, and this Waldron suggests and just sort of forgets about. On an intuitionistic theory, say a moral theory, it's not that there are sort of more important and less important statements or propositions or beliefs or judgments. Rather, we just know them by intuition, right? We know, I don't know, stealing is wrong just from our gut. We also know that harming somebody else in self-defense is okay just from our gut. And of course, that seems to work fine until we run into instances where our guts tell us different things. You know, your gut tells you, I don't know, abortion is fine. My gut tells me it's not. Your gut tells you that, you know, owning an AK-47 probably isn't the sort of thing that you should be allowed to do. My gut says it is, right? And so on and so forth. If somebody breaks into your home, your gut says you can defend yourself within reason, but you can't go to your way to cause extra harm to that person. My gut says, look, if they took one step onto my property, they forfeited their right to life, and I'm free to shoot them if I want, right? So there are situations where our guts or just our intuitions come apart. And so purely intuitionistic theories aren't really in favor anymore. The 17th, 18th century were more fertile grounds for this, in part because there was, not to say there wasn't disagreement within societies, there most certainly was, but there was a little bit less disagreement. There's less plurality than there is in the modern world. So given that we don't have intuitionistic theories as really strong contenders anymore, we have at least two models: a coherence model where we have different sorts of propositions, their judgments, and they form this kind of constellation where ideally they're mutually reinforcing, they support each other. It's problematic where you have different areas of it in conflict, right? So you've got different beliefs within the whole set of beliefs. The set is really just the whole collection of them. You've got a problem if they're running into tension or contradiction with each other. If, you know, in one part of the belief set, you hold a belief that P, whatever it is, some other part of the belief set, you hold the belief not P. Well, now you've got a contradiction in there, right? Is it really P or is it not P? Ideally, you'd like to work through those sorts of things and have a belief set that hangs together nicely. Another way is to have a foundational approach where you have certain sort of a foundation or a set of basic propositions or judgments or statements or beliefs or whatever. And then on top of that, you can build up through inferential steps, right? Justificatory steps, other sorts of beliefs. This is really what Waldron's talking about here. So he says, normally it is possible to distinguish between judgments that are more or less basic, right? Our most basic, or as he calls them, fundamental judgments or propositions, he kind of switches back and forth. So in some sense, it doesn't matter. Judgment itself is a sort of propositions. Maybe proposition's the easiest way to stick with it. But the most basic or fundamental judgments or propositions can be separated off from other judgments or propositions that are derived from them. So if we really have a set of beliefs, say moral beliefs or legal beliefs, or, you know, just beliefs about what the world's like, just, you know, scientific beliefs about matters of fact and so on, we can separate them off and figure out which ones are really basic. That is, which ones don't get support from other ones. So look, something like believing people just generally, like by default, have a right to life, right? That there's something important and interesting and morally salient about not killing other humans or not killing other moral agents without some kind of really good reason. That would probably be a basic proposition or judgment of, say, a moral theory, right? Because just think about trying to argue with someone about moral theory. If you hold, it's like, okay, so all persons have, minimally a right to their life, right? And the other person is sort of, no, why would they have that? Right? You sort of look at them and think about it. That's probably just going to be a basic proposition of your moral theory. If called upon to actually argue for it, you might actually find yourself not being able to come up with a good argument, right? All arguments have to start from somewhere. They all assume some kind of premise or something. We can't infinitely regress forever and constantly justify something by appeal to something else and justify that by appealing to something else and so on and so on and so on, right? Eventually we stop, just even as a practical matter, because we can't argue forever. We're finite beings. We don't have infinite time and energy. Our arguments have to start and stop somewhere. So the basic or fundamental judgments or propositions are really going to be our starting positions. Now, the basic propositions that someone holds or in a theory really form the basis for that theory. So when it comes to a normative theory, right, one about values, a moral theory, or perhaps a legal theory, something that's not just descriptive, but is also concerned with what should or ought to be the case. We're going to have certain basic propositions at the bottom or the foundation or the basis of a normative theory like that. And those sorts of propositions most likely are going to deal with what our rights are, particularly if we're dealing with a rights-based theory. Now here, this is 265. Waldron is also talking about Dworkin, and saying Dworkin has this typology where there are at least three types of, political theories. There are right-based, duty-based, and goal-based type political theories. And so Waldron's just sort of working with, he says, okay, let's just assume we can have this sort of typology, that there are these three different types of theories. He's going to be working within a right-based theory, right-based or rights-based. So assuming that's the way we want to approach our theory, what's really going to be at the base level of that kind of normative theory? It's really going to be statements about rights. That people have rights to life, perhaps liberty, pursuit of happiness, right? Do people have a right to a home? Do people have a right to work? Do people have right to healthcare access, no matter how expensive it is, no matter how much perhaps they themselves are to blame for their own situation? And I'm not trying to just be blaming here. I'm just trying to point out areas where whether or not somebody actually has a right to something might start seeming controversial. Do people have the right to bear arms? What does it even mean to have the right to bear arms? If we look at the Second Amendment in the United States, lots of controversy around that. What counts as an arm? Right. Do automatic weapons count? Do chemical weapons or nerve agents or nuclear weapons count as arms and hence are constitutionally protected? Does that mean felons have the right to bear arms no matter what? If you actually look at the language, it's the right to keep and bear arms. It doesn't actually say anything about owning, does it? Or does that language, the right to keep and bear arms, does that mean people have the right to own and carry and use their weapons, right? Even the question of bearing arms. Is it enough that people are free to walk around with them, but they can't be loaded? So these are the sorts of real questions that come up when we're dealing with questions about rights. If we have a rights-based normative theory, some sort of political theory, rights are really going to be at the fundamental level. Ultimately, what we're really arguing about are what people's rights really are. An argument in this sort of domain is really going to be exchanging reasons over why we think somebody, or really all people, if we're egalitarian in the sense that we think all people have the same rights, we're really going to be exchanging reasons over why we do or don't think people have some certain specifiable right or not. Okay, so this is the basic idea just being laid out in section 2 here. We can start from a right-based theory, think about the foundational, or basic level of that theory really being a set of propositions about who has what sorts of rights. Now, that was really taking it as a moral theory. So Waldron is starting thinking in terms of moral theory, and we can have a moral theory that's also a political theory in some sense that's based on rights. We're starting with rights. Now, how do you move from moral claims that people have certain sorts of rights to legal claims that they ought to have those rights? So he puts it this way. He says, the fact that in a given theory, the basic premises are best formulated as rights does not show that the derivative recommendations of the theory are best formulated as rights, and vice versa. So if we have a right-based theory, at the base level, we're really going to be thinking in terms of rights. People have a right to X, right? They have a right to be free from Y. They have a right to be free from torture, right? Harm, cruel and unusual punishment, or whatever. They have a right to life, liberty, the pursuit of happiness, right? They have a right to, say, health, right? Do they have a right to dignity? What would that be? These are good, interesting questions. Now, if we have a moral theory, and on the base level, we talk in terms of rights. That's really our starting point. And then from there, we move in steps and we derive other statements, other propositions, other judgments, and so on from that. So say you have a legal theory that says something like people have a right to life and freedom from unreasonable harm, whatever that might be. Well, from that, we probably then can derive something like everybody has a duty not to harm anybody else unless you've got, some sort of good reason to do so, such as self-defense, or your actions weren't truly your own because you're suffering, a seizure or some kind of medical condition or something like that, or from unreasonably foreseeable circumstances. So it wouldn't just be a matter of negligence. So we work our way out. We start with the basic propositions, and then we think about what those mean, and then work our way out in terms of, okay, then what does this mean in practice? And here you can just think about what Hart was talking about, what Dworkin was talking about. We can think, if we favor Dworkin, we can think in terms of principles, right? What sorts of general principles apply here? And then, of course, what's that actually going to mean in practice? If we're Hart, well, what's the law actually say? What's the rule? How does that apply to the given situation, right? Is there anything we need to do to modify it or adapt it? Is there room for discretion or something here? Same thing in this kind of thinking that Waldron's talking about. We start by saying, okay, we've got these sorts of rights, and if we take those collectively and then apply those rights to a given sort of topic or situation, what do we come up with, right? What do we derive from our, in effect, starting premises, our basic statements or propositions? How do we then go in a step-by-step manner deriving other recommendations or other statements or propositions in the theory? So just as an example, he talks some about this. I'll talk about it just for explanatory purposes. In utilitarianism, you have, and in fact, Waldron talks about this, that utilitarians themselves are quite happy with themselves, that they have this systematic approach. You've got the principle of utility. That's the POU, right? The principle of utility is really the basis of utilitarianism, right? It says, if we take Mill's formulation, actions are right in proportion as they tend to produce happiness. Actions are wrong in proportion as they tend to produce the reverse of happiness. So we've got this like core principle, this foundational principle. Now, based on that foundational principle, we can be act utilitarians. We can take it, apply it to each situation, and try to figure out what to do. Or, arguably more plausibly, we can be rule utilitarians, or as Waldron calls them, indirect utilitarians. We take the principle of utility, and then we apply it to general categories or classes of situations. And then we derive certain rules and perhaps even rights about what the principle of utility tells us to do in practice. So that principle of utility, actions are right as they tend to promote happiness, wrong as they tend to promote the reverse of happiness. This is Mill's formulation. So what does that mean? Well, let's just take lying. Does that mean you're allowed to lie to people, right? Well, how does it, it's an action's right or wrong as it tends to produce happiness or the reverse of it, unhappiness. Well, lying generally makes people unhappy. Right? So on this indirect, rule-based utilitarianism, we can say, well, it's wrong to lie to people, and you shouldn't lie to people, precisely because it generally makes them unhappy. we could then formulate that not only as a rule about what you're supposed to do, right? Or we could say something like, you have a duty not to lie to people, or you have a duty to tell the truth. We could formulate those two different ways, which might mean something different in practice, but let's leave that aside. We can also think about people's corresponding rights. If it's wrong for you to lie to me, then presumably it makes sense to talk about me having the right to not be lied to. Right? So I've got a right to be free from something. You have a corresponding duty to refrain from doing that thing to me. So what's the whole point of this? Well, really what Waldron is getting at here is this question that he's laid out in the quotation I have right up at the top there. If you have a moral theory that at its basis has statements about rights, those are the premises or the basic or fundamental propositions of the theory, does it follow that the derivative recommendations, right, that the applications, so to speak, of the theory will be best formulated as rights? His answer is actually no, at least not necessarily. Taking a look at the utilitarianism example, what's going on there? Well, at the basis of utilitarianism, the basic proposition isn't a statement about rights, it's a statement about what makes actions right or wrong, right? And that's the relation to utility. We can then derive from that statements about rights, right? Based on the principle of utility, people have rights to this and rights to that, rights to be free from such and such, and the right to do other sorts of things. Right? So you can start with rights and not wind up deriving things that are best described as rights. Alternatively, you can start with things that aren't best described as rights. It can be some kind of principle or a goal or something like that. And from that, you can then derive rights. So you might have rights at one level of the theory. That doesn't necessarily mean you're going to have rights at a different level of the theory. And even if it does mean you're going to have rights at both levels of the theory, it does not necessarily follow that the rights that are going to be derived ought to be enshrined in the Constitution. And so that's what we're going to get to. Really, Waldron is starting here with, in some sense, theoretical arguments, and he's going to work his way over to, I'll just call them practical arguments. So he puts it this way down on the bottom here on 267, and he numbers these as well. Says, look, does it follow from the statement that P has a moral right to X, whatever that is, right? So P has a moral right to, I don't know, their life or something, that P morally ought to have a legal right to X. So what's the difference there? So in both cases, there's the moral question, but it's whether or not from the fact that somebody has a right to something, does it follow that that person ought to have a legal right to what they already have a moral right to? And he frames this as a moral question. Is it the case that, morally speaking, somebody should always have a legal right to what they have a moral right to? Not necessarily, is Waldron's answer. Why? Well, it might instead follow this weaker claim that the law ought to be such that P gets X. So if P, some person, has a moral right to X, whatever it is, maybe I should go away from their life. Let's just say we think people have a right to healthcare, right? P, any person, so say Carl, has a moral right to X, healthcare, right? Is it the case that I should have a legal right to healthcare? Waldron says, not necessarily. A weaker implication seems to be that if I have a moral right to healthcare, then the law ought to be such that I get healthcare. Now, there are different ways to do that. One way is to have the law actually enshrine some kind of right that says, Carl or all Canadian citizens or whatever the group is, all people within that group have a legal right to healthcare or whatever it is. But of course, we have all sorts of entitlements that the law gives us that aren't explicitly set out as rights, as legal rights, or at least arguably that's the case. Because of course you can have a piece of legislation that says, for instance, people, the police can't search and seize anything they want. They have to have, let's just say, probable cause. Police have to have probable cause to conduct a search and seizure. Does that mean we have the right to be free from, you know, unjustified search and seizure? Well, yeah, I suppose so, maybe. But then there's a question here, and this is part of what Waldron, sorry, is going to be ultimately getting at. There are questions about how these pieces fit together within a legal system, right? If you're free from unreasonable search and seizure, there's a question, well, do you have a right to that, or is it just that there's a particular law that says police can't do that? Now, depending on how we enshrine that in law, how we write it down and everything, that's going to introduce some practical limitations on what legislatures can do in terms of how they can balance and trade these things off and revise them. It's also going to put certain limits on what courts can do in terms of taking a look at particular situations and making decisions about whether or not something can be justifiable or allowed, really by making something a legal right on a constitutional level, at least. There are certain restrictions being introduced that reduce the flexibility of parts of the legal system. Right? Now that, in some sense, is precisely what advocates of having the written constitution and written constitutional rights advocate for, but we're going to see why Waldron thinks that this is a mistake. Now at this stage, really what he's just trying to trace here is that when moving from a right-based moral theory into the zone of legal rights, it doesn't necessarily follow, right? It might follow, but doesn't necessarily follow that just because somebody has a moral right to something, that they ought to have a legal right to that thing as well. Right? We can say more simply that the law should be such that people get what they have a moral right to, without necessarily advocating that anything we have a moral right to, we should have a legal right to. So again, just think about the utilitarian case. I have a moral right to not be lied to, say. Does that mean I have a legal right to not be lied to by anyone ever? That seems like a pretty tough stretch of the imagination, right? We don't want to enforce that. That takes a lot of resources, especially if people are just telling you little white lies that have no negative results. What, do we want to pay for police and lawyers and everything to get involved and prosecute people for that? Probably not. So there are at least some cases where presumably our moral right to something doesn't automatically mean we should have a legal right to it. Even here, that the law to be such that someone gets something, whatever that is, can be interpreted a little bit more broadly. Maybe that doesn't even always follow. Okay, so on to section 4. From legal rights to constitutional rights. In some sense, I got a little bit ahead of myself here. So Waldron's starting with moral theory, right-based moral theory, right? And you can have rights at the basic level, but not, say, on the derivative level. Even if you've got rights on the derivative level, we say, yeah, people really have rights to this, that, and the other thing. It doesn't automatically follow that they should have legal rights to all the things they have moral rights to. Right? Now, let's just assume people should have legal rights in some sense, of course. Right? And in effect, Waldron isn't really arguing that people shouldn't. What he's really arguing is that the best way to approach the question of rights is in a non-constitutional way, in that majoritarian democratic fashion. And we'll see why when we get there. So this question, should any right, any legal right, be a constitutional right? Assuming we do have legal rights somehow or other. Should those be constitutional rights? Well, look, a constitutional right is different from just a normal right that gets created through, say, legislation or custom or what have you. Constitutional rights get entrenched. This is the language that Waldron uses. It's a good way to talk about it. It's a good way to think about it. I think if you think about the physical act of entrenching, right, you actually like build a trench and you settle yourself in somewhere. It's difficult to remove somebody from a trench, right? If you're thinking in terms of warfare, a lot more difficult than if they're just standing on open ground. Now, a constitutional right is one that gets entrenched in a legal system. What does that mean? That means it's very hard to change. Why? Because its existence, the existence of a constitutional right, as Waldron puts it, the existence of that kind of right is, in effect, a disabling of the legislature from its normal functions of revision, reform, and innovation in the law. Legislatures exist precisely to perform these functions, right? To revise existing law, to reform it and change it over time, and innovate and create new law to better reflect the will of the people, right? The will of the demos, the power of the people. That's exactly what a legislature in a democracy is supposed to be doing if it's functioning the way that it should. So a constitutional right gets entrenched and really disables or limits a legislature's ability to do something, to change, to revise, or innovate around those areas of rights. Now, Waldron also discusses this practical point, and of course, when you were dealing with things like legal philosophy and political philosophy, theory and practice very much come together. So, you know, that old saying, well, it's good in theory, but it's no good in practice. If it's no good in practice, then it's really no good in theory either, particularly if we're doing something like legal or political philosophy, right? Or say moral philosophy. If you've got a philosophical system that you can't apply, it doesn't work in practice, it doesn't match up with human nature or if there is such a thing, or the actual difficulties of coming to a decision in democracy or something like that, then it's not going to be a good theory. And Waldron's going to rely on this a little later in the piece, so we'll come back to it. Now, if we take some sort of legal right and make it a constitutional right, how do you do it? Well, presumably you write it down, right? It's not going to be some kind of just oral record that we exchange, in part because oral records can change over time. Now, this isn't to completely slag oral traditions generally, but at least in the Western world, the European tradition that we here come out of, or at least the style of philosophy, right? Colonial people such as myself coming from Europe, we do things in writing. So if you make a right a constitutional right, you're going to write it down in some form. You're going to give it a certain kind of wording, right? So it's going to get fixed in a certain sense. It's going to be worded a certain way, and that's going to be entrenched within the legal system. So again, if we look to the United States, that's a particularly good example. You have a very old constitution, and there becomes a lot of debate about how to interpret it. So you can't just make up a right that's not in there somehow. But of course, what rights people actually have depends on what the Constitution says and how people read it. And there are legal controversies about that. So there are different schools of interpretation. Some people are originalists. They want to read it in terms of the original meaning that the people who wrote that document would have in mind. You can have a view where you are going with the original intent of what the people had in mind. So maybe you say, look, I know they said literally this, and somebody from 1780 whatever would have interpreted that in this kind of way. But really what the framers of the Constitution meant was this other thing. We can see that in their letters and other documents and this kind of thing. So you might go based on original intent. You might go based on original meaning, right? What the average person would have understood at the time it was written. You might also have a more open view that the document changes over time as the sorts of attitudes and meanings that people share in a society have. We're going to see something like that in Wallach, so I'll just shelve that for the moment. But really the point is that you get arguments when they're about written rights in some kind of constitution. They take on a very linguistic turn, right? There's a lot of debate about what that language means, and the language used to debate the very issues in question, but whether or not people should have certain sorts of rights, in some sense, largely get sidetracked. And here again, I think you could probably think about certain debates. We get a lot of the sort of, the culture comes in from the United States. So I'll just sort of stick with that. Say on Second Amendment rights, the right to keep and bear arms. What does that mean, right? Well, we get all tied up into this question about, well, what does that wording mean exactly? And if there's a debate, right? If the debate is just about, look, should people have a right to own an AK-47, right? And walk down the street with it while it's fully loaded or not? Or like, if that's really our question, do people have a right to do that? It's very easy for people to sometimes get sidetracked and say, well, the right to keep and bear arms will not be infringed, right? Second Amendment. Look, that's what it says. So I have the right. It's like, yeah, there's the question of do you have the right based on what's in the document? Now there's the question, should you have the right? Now, I'm not actually taking up a position, right? I hope that's clear, right? I'm not actually arguing one side or the other. Yeah, there should be the right to keep and bear arms, or no, there shouldn't. But it's because it's already written, the matter of fact that there is the right there can get in the way and distract from the question about whether or not there should be the right. And when something is already written down in that constitutional form, sometimes that debate about whether or not we should have a right or don't turns into a debate about whether or not, as a matter of fact, we already have the right or not, based on what the constitutional document really means in practice. Okay, coming back to the main point. So to put a right into a constitutional form, make it a constitutional right, Waldron says, so in doing this, we're entrenching it, we're putting it into the system and making it less liable to be subject to the normal functions of the legislature, which is revising and changing a law over time. So if you have a right, but it's not a constitutional right, then really it's subject to, I'll use the phrase, whims of the legislature. That is that whenever the government changes and you have the sitting government of the day, they can change what the law is freely, so to speak, as long as they pass the normal procedures, they have a majority vote in Parliament or whatever it is, right? It gets approved by the Senate or House of Lords or whatever. The law changes. And when the law changes, the sorts of rights people have can also change. When you have a constitutional right, you make it a lot harder to change. It's not just that a majority in Parliament or Congress or whatever has to pass it. Usually there has to be some kind of supermajority or a majority that cuts across various jurisdictions and so on. The whole point of having a right in a constitution is to make it very hard to change. Now, wanting rights enshrined and entrenched that way reveals two attitudes, Waldron tells us. He says there's a combination of self-assurance and mistrust. Now, what do those mean in practice? Well, the self-assurance is the self-assurance that you have it right. When you articulate certain rights and you say, okay, here are these basic fundamental rights that everybody should have, we should put them in a constitution, we should entrench them, so no silly government at some later point can come along and say, oh, people don't have that right anymore, right? You want to protect that right from, in effect, the will of the majority. So there's a combination here of self-assurance that you've gotten it right and mistrust that the representatives of a majority of people within your political community would actually come to fail to recognize that whatever it is, that people have a right to it, and that they would try to pass some kind of law to take away that right. So there's the self-assurance that we've gotten it right. We know what the rights should be, and that they should be written down to keep the majority's paws off of it. Because of course you can't trust the majority, and who knows what silly thing they might do next. Now, Waldron says that these attitudes are really at odds with the bases of democracy, right? Really the basis, the key attitudes, the core attitudes that we ought to have while being Democrats. That is just people who believe that democracy is the right kind of political organization to have. And this takes us around to, in some sense, section 5. Now we're going to pick up on that thread. And in some sense, there's this little detour that Waldron takes, that the practice of philosophy, in many ways, is a kind of microcosm that we can use to think about what's going on in the public sphere, in public discourse. So the practice of philosophy itself should give us some lessons that we can apply more generally. So mentally, philosophers pretty much always think they're right? Whatever it is. And people in general are like this. Whatever we believe to be true. Even if we believe something else to be false, right? It's currently Monday. I believe it is false that today is Friday, right? But I believe it's true that it's false that it's Friday, right? If F is today is Friday, I believe not F, right? But I positively believe not F. I believe not F to be true because I believe F to be false. So philosophers, like everybody else, we think we're right. But philosophers at least should know that they're fallible, right? From engaging with other philosophers, with other people who think about these sorts of matters seriously, we know that any proposal, any theory, any position can be subject to some kind of reasonable disagreement. Sometimes it can be fairly small, but if there's anything worth saying, then it's only worth saying precisely because reasonable people might think that there's something wrong with it. Now, a theory of rights, to really be a decent theory, to be an adequate theory, needs to address at least 4 things. Waldron doesn't quite outline them, he doesn't sort of 1, 2, 3, 4, but you can find these 4 points in his discussion about these sorts of things in this section. So an adequate theory of rights will have to tell us what rights subjects actually have. So saying in Canada, what rights do the citizens of Canada have? What rights do anybody subject to the law have, right? Citizens, non-citizens, permanent residents, visitors, et cetera, et cetera. B, what those rights mean in practice. Just say somebody has a right to life or liberty or the pursuit of happiness or right to health care or right to be free from harm or whatever. What does that actually look like when we apply it, right? How do we interpret and apply that to particular situations? The adequate theory of rights is also going to have to tell us C, how rights interact with each other. If people have rights to various things, what happens when there's a tension between those rights? Say I have a right to dignity, but you have a right to freedom of speech. Does that mean you're allowed to say, racist and hurtful things towards me? Well, it's a good question. These are really the questions around the issues of hate speech. And in fact, legally speaking, in Canada and the United States, they're handled differently. They get weighted differently, how those rights interact with each other. And finally, D, who are the rights bearers? What sorts of creatures have what sorts of rights? So look, in Canada, humans have lots of rights. Adult humans, right, that have their full cognitive faculties and so on, have the most rights. Children have rights. Say seniors, if they're experiencing certain forms of mental decline, might have different sorts of rights. People that have mental disabilities might have limited rights. People like, say, permanent residents or just visitors may have different sorts of rights as well. What about non-humans? What sorts of rights do pieces of property have? What sorts of rights do plants and animals have? What about different kinds of plants and animals? What about ecosystems as a whole? These are all interesting questions. They're important questions, right? And if you want a good theory of rights, you're going to have answers to all those questions. Now, what's the whole point of this? Well, the whole point of this is that coming up with a theory that answers all of those questions well and answers them in the best possible way is no walk in the park. Going back to the decline of intuitionistic philosophical systems, it's in some sense an overconfident or perhaps sort of lazy person who thinks they can look at those 4 questions, scribble off answers that they take to just be self-evident that anybody who thought about them would come up with. If we're being serious, say like a good philosopher, just a good thinker, shelf even what it is to be a good philosopher, we're going to have to recognize that coming up with good answers to those questions is tough work, and we might get it wrong. We are fallible, right? We might be convinced we're right, and only by talking with other people, hearing other views, seeing their objections, thinking about what it is in our view that's really right, what's really wrong, thinking about it over time. It's only by going through this process are we really going to work through what the best answers to those questions really are, right? By engaging with each other, we produce better theories that are hopefully, perhaps optimistically, closer to the truth than we could come up with on our own, right? It's this practice of engaging with each other that helps make us better over time. Right? So, the practice of philosophy itself, Waldron thinks, really gives us this nice microcosm for thinking about public discourse, right? We've got tough questions to answer. We answer them as best we can, and we all think we're right about it. But when we actually engage with each other, we realize that there's limitations on all of our own thinking. So, I think I'll probably just leave this section there. I was going to say a little something else, but no point in overdoing it. So this final point is one that I really just already made, that it's only a kind of overconfidence that might lead us to think nothing good is going to come from having serious good faith discussions about difficult questions such as the ones outlined in A through D above. All right, let's do this section 6. This very well might be the last section for this video. I'm trying to keep track of the time and keep the videos sort of roughly what they should be in terms of class. So we're going to have disagreement, right? Just like philosophers disagree with each other, citizens disagree with each other, jurists disagree with each other, politicians disagree with each other about how to answer some of these tough questions. Right? Now, related to these questions about rights and having an adequate theory of rights are also questions about the nature of authority, right? What is that makes an authority legitimate versus de facto? Remember our discussion of Raz, right? There's actually some interesting overlap here. Like Raz, Waldron holds that legitimate authority has some kind of role to play in settling decisions or settling questions, settling arguments when there's disagreement over what to do or what we should believe. So assuming we're in a situation where people have some kind of disagreement, but we really need a decision of some sort, a legitimate authority has some kind of role to play in helping us figure out which decision's actually going to be made. Right? Now, legitimate authority is going to determine who decides and how they decide, right? So if we have a legitimate authority and really even a theory about the nature of authority, it's going to have to tell us when we have this kind of disagreement, say political disagreement, who is it that gets to make a decision, right? Say, members of parliament or something like that, or maybe it's judges or whoever it might be, based on what the disagreement is. And then there's going to be the question of how, right? Some sort of decision-making procedure. So in Canada, just sort of generally speaking, I'm just sort of doing broad brush here, when there are questions on the federal level, so as a whole country, when we're trying to figure out what we should do, say as a matter of criminal law, that's something that's settled at the federal level. Well, who gets to decide that? Canadians don't all believe the same things, right? You just look at euthanasia or abortion or gun rights or all kinds of different stuff. So who gets to decide? Well, in short, members of parliament, right? How do they get to decide? By voting, right? And they discuss and they have committees and they do all sorts of other stuff as well. But when it really comes down to it, how do we settle these disagreements? Members of parliament get together and vote, right? And there are certain other procedures, right? They can't just, get together at the local bar or something and do a vote, right? They have to vote in certain ways at certain times in certain sorts of places. There's certain customs and traditions associated with it. Themselves, they can change depending on what's going on, right? Parliament Hill is being renovated at the moment, so there, some things that are usually done one way are being done another way. But the short answer is that within a system, if there's a legitimate authority, right, it's going to have to figure out how to settle these tough questions. And a good theory about the nature of authority is going to have to tell us how that works, right? It's going to have to help give us some answers about these questions. Waldron notes 3 things about the relationship between theories of authority and theories of rights. So first, an adequate theory of authority will complement our theory of rights, but not replace it. These are 2 separate questions. Questions of what sorts of rights, moral, legal, constitutional, that should people have, is a separate question from what is the nature of authority, what's the nature of legitimate authority, and what role does it play in settling disagreement between citizens or members of the body politic or whoever it might be when they disagree. So we're going to have 2 separate theories, some kind of theory of rights, some kind of theory of authority, right? They're going to interact, right? And hopefully interact in a sensible way. That's why they'll complement each other. But one isn't going to replace the other. Second, a theory of authority must really tell us who gets to decide and how. Just like Raz, we can't say something like the right answer is the one that should be chosen. Right? Waldron puts it in a slightly different formulation. That's just my own way of putting it. And remember Raz, when he talks about the the conception of authority he's dealing with there, the service conception. I'm drawing a bit of a blank here, but right, we take something like a mediator as the sort of paradigm. You've got two people, they disagree, they both got reasons for their positions, they put it forward to the authority then has to actually take those reasons into account, weigh them up, think about the matter, come to some sort of decision, has to actually tell people what that decision is or how they came to it, right? We have to have some kind of explanation about how that authority functions. The authority can't just say, well, I've made the best decision. I'm sure you can figure out what that is, right? No, we can't. That's why we need the authority in the first place. So here there's significant overlap between Waldron and Raz. Lastly, the third point, this is the really interesting one. There will sometimes be dissonance between what one takes to be the just choice and what one takes to be the authoritative choice in political decision-making. What does this mean? Really, it means that an authority may make the wrong choice. What does wrong mean? Well, a choice other than the just one. Let's just assume, which when you're doing normative theory, you're doing legal philosophy or political philosophy or moral philosophy, generally speaking, not exclusively, not necessarily, but generally speaking, there's a bit of a presupposition that in fact there are moral truths, right? There are things worth arguing about here. We're not just expressing our feelings, we're trying to actually work through reasons to help us figure out what's really right, what's really wrong, what's good and what's evil and so on. So assume there really is such a thing as justice, right? And assume rights are a matter of justice. What should our rights be? Well, we're going to have some theory of rights, and of course we can disagree about what our rights should be, what rights we ought to have, and so on. Now, we also need some kind of theory of authority that tells us how to settle our disagreement. So we can have a situation where we disagree on what our rights are. We have some kind of agreement about how to settle our disagreement. The authority, we have some kind of legitimate authority, right? We agree, okay, we'll use the mediator or parliament or whatever the procedure is to settle our disagreement. A decision gets made. Let's assume in reality, the decision made is the wrong one, right? It's decided that citizens don't have a right that they really should, right? Or conversely, it's decided citizens should have a right that they really shouldn't. Waldron wants to allow here that this is an open possibility, that although we have to have a relationship between rights and authority in our best theories, that relationship itself can give rise to potential problems, right? You can have a situation where a decision gets made that really isn't the best decision, but it's the one made based on the agreed upon decision-making procedure used to settle cases of disagreement. This produces what almost seems like a paradox, and Waldron talks about it this way. The paradox seems to be that somehow the wrong decision becomes the right decision because it's produced through the right sorts of procedures. Now, Waldron doesn't think that there's really that kind of paradox here. He thinks there is, some suboptimality. It's not the best thing ever that this is the case, but it is the case. That's just part of the world we live in. That's part of what it is to be human and to have our flawed thinking, our disagreements, our flawed procedures of solving those. We are not idealized agents, right? We actually think and get things wrong and hopefully get better over time. There's no necessary guarantee, but we can certainly hope. So we can have situations that are suboptimal, that an agreed upon authority makes a choice that turns out to be the wrong one from a moral perspective about what really should be done. But we have to accept that as sort of settling the issue, at least for now, because it's done in the agreed upon method. So I think I'm going to go ahead and stop there for today's portion of the lecture. I think I've probably already hit about the amount of time I've had. So we'll pick up on Wednesday from section 6, and we'll finish the piece off. And so we'll take a look at the rest of Waldron's case for why he thinks it's really best not to entrench certain rights on a constitutional level, and instead leave rights in the sort of give and take of democratic, participatory democratic forms of government, where we agree upon some sort of authoritative decision-making procedure that can produce the wrong results, but can still be worth having and abiding by, even though it can be this kind of imperfect system. He thinks it's still better than the alternative of entrenching rights within some sort of written constitutional form. So we'll hear more about that on Wednesday, and then next week we'll take a look at Waldron. I hope this video has been as clear as it can be. I hope you're all doing very well. I'll see you again on Wednesday. Bye for now.